This is the time and place for the consideration of the case of Sandra Mellott versus Mother Lode Theater, case number 240284. This case is before us on charging party's objection to the Human Rights Bureau's finding of no reasonable cause and notice of dismissal of the charging party's complaint. Once again, for the record, I'm Peter Damrow, Chairman of the Montana Human Rights Commission and the presiding officer for these proceedings. Will the other commissioners please indicate whether they've reviewed the complete record as submitted by the parties as I call their names, beginning with Commissioner Almy.
Commissioner Almy and I have reviewed the entire record.
Commissioner Molina.
Commissioner Molina, I've reviewed the entire record.
Commissioner Bartos.
Commissioner Bartos has reviewed the entire case record.
Commissioner Sartain.
Commissioner Sartain reviewed the entire record.
I've also reviewed the records, while members participating have indicated they've reviewed the entire record. Just as a reminder, both audio and video are being recorded and will become part of our official public record for this hearing. So in this particular matter, the parties have requested oral argument. So we will begin with the claimant who may come up and make her argument. And then at that point, you'll have 10 minutes to make your argument. And you may reserve any portion of that for rebuttal. And then at the end of your questioning, I will turn it over to counsel for Mother Lode Theater as the respondent. And then after both parties have had a chance to give their argument, I will open it up to the commission for questions. And then during our argument, Anna Howard will serve as your timekeeper. So please keep an eye on her to keep track of how much time you have remaining for your argument. Is Ms. Mellott here joining us online? Excellent. And Mr. Olvera, so any questions of the procedure before we begin? Okay. Ms. Mellott, as the charging party, you may begin. And would you like to reserve any portion of your argument or your time for rebuttal?
Yes, please, and thank you. I would take 4 minutes for my rebuttal. If I finish earlier, I'd like to reserve all my time, but at least 4 minutes.
Certainly. Okay, you may begin when ready. And if you could, once again, please identify yourself for our record. Thank you.
Yes, thanks. My name is Sandra Mellott, Mellott. I think all of my allegations against the Mother Lode Theater are valid, but today we only need to focus on one: failure to accommodate. The Mother Lode Theater did not engage in a good faith interactive process or provide me with accommodations. The investigator was wrong to say they did. In the Mother Lode Theater's words, the commission may reject or modify an investigator's conclusions of fact if the commission reviews the record and states with specificity that there was not substantial evidence supporting the conclusions of fact. And there's not substantial evidence. There's not even a scintilla of evidence. I worked at the Mother Lode Theater for over a year and a half, where board meeting minutes called me stellar and invaluable. Then the previous managing director was replaced with new hire Tom Webster and board president Jocelyn Dodge, who had not previously been involved with staff. Within 4 months under this new management team, I was subjected to 6 disciplinary meetings and fired. In that time, I also disclosed having autism, depression, and post-traumatic stress disorder, and formally and informally requested accommodations at least 8 times. I also complained of constant misunderstanding and repeatedly expressed both a willingness to obey and a desire for healing and cooperation. I truly thought my accommodations requests would open a good faith interactive process. A month and a half after my initial request, when the Mother Lode Theater scheduled a meeting with me, I thought it was going to be to discuss my requests and explore options. Instead, without having consulted me at all, they handed me a signed letter saying all of my requests were denied, and if I wanted to talk more, ask. So I did. My requests were to help me with communication challenges. Quoting from the exhibits you have in your record, on the many occasions captured in the evidence where I kept trying to have a conversation about the accommodations I needed, the Mother Lode Theater responded as follows. on February 26th. Thank you, Sandra. I am wrong. I was going off of what someone shared with me, and I should have done my research. But at this point, we are going to stay with what we have been advised of. On March 5th, your persistent request to reconsider after I said no could be considered insubordinate. On March 8th, Sandra needs to improve communication, and the responsibility to improve is yours alone. On March 15th, you want someone to be here every time we talk, like I'm not a good communicator. How do you think that makes me feel? On April 5th, you want to get on my bad side? Keep this up and find out what happens on my bad side. Also on April 5th, I said, I don't want to avoid the subject, but I don't want to cause upset. So should we schedule a different time to talk? And Tom said, I'm not talking to you anymore. Also on April 5th, Sandra kept asking about her accommodations, which was denied in February. Sandra continued to ask. I felt Sandra was insubordinate. On April 26th, they fired me for insubordination. In addition to the denials already quoted, the Mother Lode Theater responded to my charge of discrimination by writing, Mother Lode Theater admits that it denied Mellott's accommodation requests. Yet somehow the investigator found, quote, no evidence that Mother Lode Theater failed to accommodate. The Montana Human Rights Bureau's YouTube training video on reasonable accommodations says, the interactive process requires communication and good faith. When a party obstructs or delays the interactive process, that party is not acting in good faith. So, on one hand, the direct evidence positively shows that the Mother Lode Theater obstructed and delayed by refusing to engage with me, rejecting my input, as well as by explicitly denying every request I presented. And on the other hand, the evidence fails to show any accommodations actually being provided. Both of these facts contradict the investigators' clearly erroneous and apparently arbitrary or capricious conclusions and warrant upholding my objection and remanding the case to hearing. Thank you. I reserve the rest of my time.
Thank you, Ms. Mellott. Mr. Oliveira, come to the podium. And
morning.
Commissioner Sartain, can you see Mr. Oliveira?
Yes, thank you.
Okay, better.
Perfect. Good morning. May it please the commission. My name is Chris Oliveira. I'm an attorney with the Crowley Fleck Law Firm here in Helena. I represent Butte Center for Performing Arts. It's doing business as Mother Lode Theater. We're going to stand by on our response brief that we filed related to all the claims that were being asserted by Ms. Mellott in this case, but I do want to address specifically our argument related to the reasonable accommodations issue. The reasonable accommodations in this case, and if you look at the investigator's report, was it's not that they denied the reasonable accommodations. Some of the reasonable accommodations were already being provided to Ms. Mellott. And so that's the issue here. The issue is, what did the investigator do? What did the investigator review? And how did she come to her decision in determining that appropriate reasonable accommodations were being made? And so, and I remind the commission here that your job, and I know you guys know what your job is, but it's not to substitute your judgment for what the investigator did in this case. So let's go back and let's talk briefly about that. Ms. Mellott requested reasonable accommodations after receiving disciplinary notice. There was 5 requests for different reasonable accommodations. And I believe that 3 of those were already being provided to Ms. Mellott, and a couple of them were denied. And they were denied because they were not feasible or reasonably practical. So one of them was audio recording every conversation that was going to occur. That was denied, but what was given was you can take as many notes and we can have clarification and communication sessions about those notes. And that was being provided. And so the standard for the interactive process is not, it's not that what the employee offers, that's what the employer has to agree to. It's an interactive between the employer and the employee to have a discussion and find something that's reasonable for the parties. And ultimately, Ms. Mellott stopped communicating about the interactive process. And so the interactive process ended on her side, which means it ended. It was over with. So either there was an agreement between the parties, that's what was going on. And so that's where this really ends, is they engaged, they denied some, they proposed some other alternatives, nothing went further. And so they continued forward with her. And unfortunately for Ms. Mellott, her performance suffered as she continued forward over the next several months, and ultimately, which led to termination. So what Ms. Mellott wants to do today is re-argue what the investigator did during her investigation and the conclusion that she came to. That's what she was charged with. She interviewed witnesses. She gathered documentation. And after weighing all the evidence she had, the credibility of the witnesses she talked to, the documents she reviewed, she made a decision. She's in the best position, that investigator, Mulcahy, was in the best position to make a decision whether or not reasonable accommodations were made for Ms. Mellott. And so her decision was, as you see in her final investigative report, which is a thorough discussion, that those reasonable accommodations were met, and it was sufficient under the law as to what the Mother Lode Theater did. Okay. So in the end, what we're asking this commission to do is not go back to second guess what the investigator did in this case. What we're asking the commission to do is uphold the decision of the investigator, the decision in the final investigative report that there was not, that the reasonable accommodations requested and how the Mother Lode Theater did the interactive process, that was met. So that's what we're asking, is that stand by that decision of the investigator, but also on all the other claims that are being asserted in this case. I think the brief in this case is pretty clear that it's a re-argument of the facts. You'll see that there was additional facts that were added to this case that could have been provided, but were not provided to the investigator. This is a case that, as the commission knows, it's a 180-day statutory time period to investigate. This is a case that mediated, so it extended to 225 days. There's 225 days to provide all of that information. It just simply wasn't provided. Perfect. So again, on all the claims, what we're saying is that the investigator did this absolutely correct. She did her interviews, she reviewed the documents, and made the right decision under the law and on the preponderance of the evidence standard. Be happy to answer any questions that the commission has after the rebuttal by Mrs. Mellott, but appreciate your time this morning.
Thank you, Mr. Oliveira. Ms. Mellott, I believe you have how much time? 4 minutes left for rebuttal.
Thank you. This is Sandra Mellott. Mr. Oliveira claimed that alternative accommodations were provided to me. I noticed that he didn't point to any specific exhibit in the record showing that. My argument has always been there is no evidence of that. And I certainly say, I'm telling you, nothing was provided to me. He mentioned some accommodations and perhaps weren't feasible. I'd like to quote the Human Rights video, again, the Human Rights Bureau's training video, that says, for example, if the cost is too burdensome to the employer, that's the quote, and continuing the quote, the employee should be given the opportunity to pay the difference. Because there was no interactive process, that never came up. It wasn't an opportunity that was given to me. I would also point out, he said accommodations were already being provided. And again, to quote the video, an employee may need more than one accommodation. There is no limit to the number of accommodations needed. And my contention is that the behavior they observed in me and that they didn't like was caused by disabilities. And I continue to request accommodations for those which were never discussed or provided. He said the interactive process was ended by me. I made my first informal accommodation request, I believe, January 11th. I made a formal request February 8th. That request was referred to by Tom Webster April 5th when he wrote in evidence, Mother Lode Theater submitted themselves to the record. Sandra continued to ask about her accommodations, which were denied in February. I felt Sandra was insubordinate. It's not likely to me that the argument would stand that I ended the interactive process when months after my initial request, I was still requesting. And in fact, on April 5th, that meeting that Tom was referring to was very contentious. And I believe it was 4 days later was my last day of work there because they put me on administrative leave and then fired me. So I don't think that argument stands. I had some other notes. Let me see. I also wanted to say, yes, to quote again the Human Rights Bureau's training video. It may be easy to accommodate your stellar employees. It can present a challenge to accommodate a more difficult employee, and yet your legal obligations are the exact same. The Mother Lode Theater argued against questioning the investigator's decision, but it is the commission's job to question it, to determine if it was fair. If it was fair, why be afraid of questioning it? Moreover, the Mother Lode Theater started with false information. I corrected them, yet they continued to stand by their false information. They said, your accommodation requests do not relate to major life activities. They relate to communication. I quoted the Americans with Disabilities Act to them. Major life activities include communicating, but their answer was, we're going to stay with what we have been advised of. They also said, Mother Lode Theater does not have the requisite number of employees that would impose the requirements on them. And as an employer with less than 15 employees, the Mother Lode Theater is not bound by federal law. Yet, there are at least 19 different employees named in this appeal record alone. I noticed that Mr. Oliveira said I provided additional facts in this appeal. I also noticed he didn't point to any specific exhibit showing what those additional facts would be. And I recall in their response, they objected to certain items that were included, apparently without realizing that they were the ones who originally provided those documents. So I think the Mother Lode Theater is grasping at straws and not making sound arguments. So the investigator made a conclusion which wasn't supported by evidence, disregarded evidence suggesting Mother Lode Theater argument. Oh, thank you.
Thank you, Ms. Mellott. Before I open it up for questioning, Anna, can you tell, is that an audio issue on our end or Ms.
I
Mellott's?
can't tell. Ms. Mellott, can you mute for just a second? Connie, can you say something? Let's see if there's a problem on your end.
How's it going down there?
It's going
Does
good.
mine sound okay?
Yep.
Okay.
So Ms. Mellott, it sounds like there's some buzzing on your end. I'm not sure what's going on there, but just so you're aware.
Okay, thank you. Can I just say, if there was any part that you didn't hear or understand, please, I'd like the opportunity to answer questions to clarify anything you might have missed.
So, certainly, now you're coming through very clear. So thank you for that. And at this time, I will open it up for questions for you, Ms. Mellott, from the commission.
Mr. Chairman,
Mr. Bartos.
the question is for Ms. Mellott. To clarify, are you suggesting or are you now stating that you've withdrawn the other two elements of your appeal, the retaliation argument, and the second was the I think the termination argument? And you're solely just looking at the reasonable accommodation argument?
Thank you, Commissioner Bartos. To clarify, no, I'm not withdrawing any of my claims. I just thought that the strongest claim, the one the investigator got closest to, was a failure to accommodate. And so I focused my attention on that. But I still believe all of my claims are valid.
The second question is, the commission always struggles with the issues that are presented to us, but we are tied within what's called a standard of review. And it's been mentioned both in both briefs and the extensive paperwork that it was in the case record. Are you arguing specifically that the investigator committed error because of the first standard, and I'll read you the standard? Did the investigator act arbitrarily without conscientious judgment? Was the decision random, unreasonable, or seemingly not based on the existing record? Is that the issue that you're presenting to the commission?
Yes, indeed it is, Commissioner Bartos. Thank you. My contention is that the investigator made a conclusion not supported by evidence. Therefore, it had to have been arbitrary or based on something other than, the record, and that would count as an abuse of discretion. It violates your standards of review contain. Mr. Oliveira said, I'm trying to re-argue the case. I'm not trying to re-argue the case. I'm trying my best to show that there's nothing in the evidentiary record supporting her conclusions. I don't see how the investigator could justify her conclusion. So I don't see how the Human Rights Commission could either. It's an error.
Thank you.
And Ms. Mellott, I want to clarify something you said a moment ago during your argument. I believe you said that you were allegedly denied all accommodations as part of the interactive process. But I note in our record there is note in our record that you were provided a private workspace, timely responses to requests of yours, written meeting notes, those certain requests. I mean, were you granted those as accommodations in your role?
Commissioner Damrow, I believe you're referring to the exhibit that shows what I called their denial script that had all those references to things provided. And I wrote in my briefings that that script, so to speak, was never provided to me. The content of it was never conveyed to me. I didn't actually even request a private workspace. I requested not to be interrupted during communication because it exacerbates my disabilities, to be my post-traumatic stress disorder and autism, especially. When communication is difficult, I shut down. And if I'm interrupted, I don't have the same ability to continue that perhaps someone without my disabilities would have. And so the idea that providing me a private space to work was an accommodation is a mischaracterization on their part. It's twisting what I actually tried to request into something they could justify. Well, she had that, so we don't need to give it. And for example, the follow-up summaries, written notes, I was taking notes anyway. So in a sense, that was sort of already provided, that I was doing my best already. The point of requesting accommodations is whatever is already existing doesn't work for me. I wasn't able to do what I needed to do. And so I had to request alternatives, like to what the already existing status was. That is what an accommodation is. It's a change to what you're already doing to enable me to do what I need to do. And so, as I said, with the lack of interaction, with the mere denial. We told you already, we're not doing that. There's no conversation. For instance, no one asked, why is this difficult for you? What do you need? No one asked, what do you need? I could have come up with so many more examples. And just every time I tried, I was in trouble for it. And so it was very difficult for me to even make the requests, let alone receive accommodations. It was not in good faith in any way. So I'm sorry, I kind of went a bit further, but does that answer your question?
Yeah, for the most part, and just to kind of piggyback off that. So in Mother Lode's letter of February 26, 2024, where they denied some of your accommodations, I think the investigator found that they did actually provide alternatives for some of those they actually denied. I mean, is that something you dispute?
Yes, I absolutely dispute that. I have no idea how the investigator determined accommodations were provided. My only thought was she simply took them at their word when they said, yes, we didn't do anything wrong, because the letter says everything was denied. And I gave you everything I have. The Mother Lode gave you many things. And there's nothing in there that shows what the investigator was talking about, saying accommodations were provided.
So my last question, other than your allegation that the investigator erred or used their discretion in finding that you and Mother Lode had engaged in, good faith interactive process, are there any other allegations of abuses of discretion that you are claiming the investigator made as part of this process?
I think one, for example, is, she said I was not demoted. The Mother Lode has claimed, my title was never changed, my job description was never changed, and my pay wasn't changed. I can acknowledge my pay did not lower to the amount that I was originally hired under. I had received a raise after being hired, and they didn't lower it again. However, I was hired as box office manager, and I contend I was promoted to a few times, actually: front of house coordinator, patron services manager, operations manager. Those are not clearly explicitly shown in evidence other than my email signature changed to those different titles. There is, however, one exhibit, the board minutes, saying Sandra was promoted to front of house coordinator, and and the board approved of that with a pay raise. And so even if maybe it's harder to show with explicit direct evidence like that, I was demoted from, for example, operations manager back to box office manager, I feel it's fairly clear I was at least promoted to front of house coordinator and then was returned to box office manager. And also that my job description did change. You have the job descriptions and also a document showing that I kind of summarized the differences between them. And my original job description that I was hired under said manage cash for the establishment. And the one they put me under afterward is have knowledge of how the cash is handled. So it reduced the prestige and the responsibility from being a manager and having that role to merely understanding that other people did those things.
All right, thank you, Ms. Mellott. Questions from the other commissioners? For Ms. Mellott.
I have one additional question, Mr. Chairman. Ms. Mellott, in the final investigative report, especially on page 19 of our case record for purposes of the other commissioners, the investigator highlighted the lack of a healthcare provider information. And the investigator said it would have been helpful had you provided healthcare information, a diagnosis, maybe some assistance from a healthcare provider's recommendations, and you didn't provide that, or that, at least that's what she concluded. And likewise, I'll ask that same question to the Mother Lode. of why wasn't it provided? And did in fact the mother lode try to receive that information?
Yes, thank you, Commissioner Bartos. This is Sandra Mellott for the record. As the commission knows, there are no magic words required when you're making an accommodation request. And there are many circumstances, most circumstances where medical, documentation is not required, particularly, if they simply believe you have a disability, that is enough. I would have happily provided it had I ever been asked for it. I have documentation. I would have consulted. I would have gotten letters, anything they would have wanted. They could have met the various providers if they wanted. With my diagnoses, autism, depression, post-traumatic stress disorder. They never asked. I suppose I could say it never occurred to me to bring it up because it seemed so obvious that they accepted, yes, I have these disabilities. It wasn't an issue of they didn't believe me. It was an issue that they believed I had them. They just weren't covered by law, or they weren't covered by law, because they didn't have enough employees, even though they did. And they didn't engage with me to find out, well, you say you have this, but what does that mean? What should we look for? What can we help with? They just didn't do anything, if that.
Thank you.
Thank you.
Further questions for Ms. Mellott? Okay, thank you, Ms. Mellott. Mr. Oliver, if you would please take the podium. Questions for counsel for Mother Lode Theater?
Yes, Mr. Oliveira. Oliveira. The same question with regard to the healthcare information. The investigator indicated, or at least directly or indirectly said, if we got healthcare information that would have provided further clarification, more, perhaps even recommendations or assistance in the accommodation process. Was that request ever made or sought by the mother lode?
It was not. The request was not made to Ms. Mellott seeking healthcare information. The mother lode didn't dispute that she had a disability. And based on the accommodations that were being requested and some that were being provided and some that were being denied, they didn't believe that it was necessary that a healthcare provider should involve themselves in the situation, or they needed additional information. We could speculate what it would say, but it wasn't at that point going to change their decision. They accepted her disability and they were trying to work with her within reason under the law to find an accommodation that worked for both parties.
Okay, thank you.
Commissioner Alvey?
I got a quick question. I see on one of the tax documents listed 26 employees. I see another place they claim it was 9, and then 15 is some sort of a magic number. Explain to me how you can have both numbers and the difference that 15 number makes.
Let me start with the 15 number. So, and I may get this wrong, and there's some smarter lawyers sitting behind me who will correct me if I'm wrong, but I believe under the ADA, you have to have 15 employees to be subject to the federal law. Now, under state law for the Human Rights Act, you have to have more than 0 employees. You have to have at least 1 to be subject to the State Human Rights Act. I think it was a technical statement, this issue as to the ADA, whether or not it applied. I believe the HR consultant for the mother lode said they're not subject to the ADA, which is true, as technically they're not. But what we do know is Montana and the Montana Supreme Court has said when you're interpreting the Montana Human Rights Act, you look to federal law for guidance. So really, you're going to follow what the ADA says. And so I think and then going to the second part of so that's the issue with the 15 employees. And I believe that it's the 990 because they're a nonprofit, is that some of those are volunteers, some of those are part-time employees, and so they have to be disclosed. But for full-time employees, I think it was 3 to 5. I can't remember the exact number. They didn't have to apply. But in the end, and I don't mean this in a rude way, it's irrelevant because they're gonna follow, the mother lode was gonna follow what federal law would do, interpretation of the ADA when applying the state act.
Mr. Olver, could you just kind of, again, just briefly walk us through, again, the interactive process Mother Lode had engaged in with Ms. Mellott, kind of the dates to the extent you can remember them, what was provided when, and then after that end of February letter, what was in place and had been granted at the time, and then what was denied, and then where did it go from there?
So yeah, there was a disciplinary meeting in January, and then ultimately after that, I believe it was the 26th of January was the formal request. Maybe it was the 19th by Ms. Mellott saying, these are the specific needs that I need. And so there was 5 requested reasonable accommodations. And then the mother lode responded to those shortly thereafter. And I apologize, it's the end of January, first part of February, with going through each one. And what we do know is the investigator did the same thing in her analysis on pages 16 and 17 of the final investigative report, walking through those. And so as we walk through those, the first one, I believe, was the notes. And so clarification. So they were already allowing that. And we're willing to work with Ms. Mellott and continue to work with her on those. There was one to basically have a mediator at every meeting, which they denied. It wasn't reasonable. I mean, this is an organization that is, it's a small organization. They're a not-for-profit. They have a volunteer board. They don't make a ton of money. And so essentially what was requested was, hey, Mother Lode, you pay for a mediator to sit in every single meeting that Ms. Mellott was in. Imagine, and I'm just gonna rough numbers here. If you're gonna pay that person $20 an hour to come to every meeting, we're talking almost 40 hours a week. That could have been a cost, if you multiply that out, over $40,000 a year, just as a reasonable accommodation. This isn't an entity that could afford to do that. So that's why they denied that. That was going to create, as the commission knows, an undue burden. And then the other request was to audio record every conversation. Well, that leads to, we have a Privacy and Communications Act in the state of Montana, that both parties have to consent to an audio recording. And there was concerns about what information would be on these audio recordings. And then it becomes, well, let's listen to the audio recording and let's walk through it. You said this and you said that. At the end of the day, at what point is the theater going to be run versus re-listening to audio recordings? And then I believe that the final one was questions, if she had questions, for them to be reviewed. And so there were email communications. So if Ms. Mellott had questions, she could follow up. And have those conversations with Tom Webster. Where there's the rub here in this situation is, it's not these emails saying, hey, I need more further clarification. It was the insubordinate behavior. And there is a delineation between those two in this situation. What you have to remember is Tom Webster has 30+ years in the box office industry. He's the guy that ran the University of Montana for 25 years. He taught as a faculty member there for over 15 years. He's the guy that brought Rolling Stones to Missoula. He ran and booked all of those events. The guy has the knowledge to do it. So when he was hired after the last managing director to come in, he was tasked with reorganizing this, what was going at the Mother Lode, because they had some prior disorganization going on with the prior leader. And he was making changes. And because he's the guy that knows how to run these organizations. And so when there was pushback as to how the organization was run, that was the insubordinate behavior. What's trying to be melded together is, well, I'm asking questions. Well, no, those weren't questions. This is, I'm not going to do this, or that's not the right way. that doesn't mean that you're asking for a reasonable accommodation. That's the insubordinate behavior. So going back, the timeline is they continually worked on these, but they had to outright deny the mediator and the audio recording. That just wasn't going to work.
Did Mother Lode offer alternatives to any of these that were denied? Or I think the investigator explicitly found that, you know, through that letter, some alternatives were provided. So I mean, what
Right.
alternative accommodations were provided?
Outside of like the mediator and the audio recordings.
I believe so. That's how I interpreted it.
It's having the one-on-one meetings. It's having, you know, somebody else present, working through the issues, having conversations, seeking clarification. But what it turned into is, well, no, you said that, and you said this, and it just turned into this very insubordinate behavior where I'm not going to do it. It wasn't seeking a reasonable accommodation. It was arguing about what needed to be done to get the work done. And so this was ongoing, and that's what ultimately led to this situation is, and what this commission knows is it led to 2 months of trying to work with Ms. Mellott to get her performance in the right way. They wanted her. They wanted her to stay. It's expensive to go out and get new employees and train them and get them on board. And they tried to work with her, and Ms. Mellott even admitted, and it's in the final investigative report, to save her job, she filed alleged claims of discrimination by Tom Webster. And she admits it was only done to save her job. It wasn't done with the expressed intent to work through these reasonable accommodations. She was so dissatisfied and concerned about her job, she did it to save it. And that's the behavior that was at issue.
Thank you, Mr. Oliveira. Any further questions? Seeing none, you could have a seat, Mr. Oliveira. Thank you. And at this time, I will open it up for discussion amongst the commission.
I'm so sorry. This is Sandra Mellott. I raised my hand, but I wasn't sure. Can I ask a clarifying question?
Ms. Mellott, we closed questions from the commission at this point, so now we're going to proceed to discussion.
Thank you.
Thank you. Great. Bartos.
Well, I'll start, Mr. Chairman. Thank you. Again, we're limited by the standard of review. We don't second guess decisions by the investigator. We review the investigative report, and the burden really is on the charging party to demonstrate that there was, the investigation was random, unreasonable, or seemingly not based on the existing record. I've read through literally, hundreds of pages of this case record, but I go back to a couple of the pages right in the final investigative report. The investigator laid out the 5 accommodations that were requested. The investigator clearly then delineated the pros and cons of each one of the accommodations, and what the parties insisted and how the parties reacted, and did so in I think a very sequential, very orderly manner. And I was not able to see any arbitrary decision-making process. She did not omit any pertinent information other than the healthcare information, which would have perhaps provided more guidance on the part of both parties in terms of how to deal with an individual with the disability that the charging party had maintained. So I have difficulty finding a reason to sustain the objection.
I would echo a lot of that, Commissioner Bartos. I think that was well said. I do think the investigator did find adequate grounds for that. The fact that both parties did engage in the interactive process in this case. Some accommodations were granted, others were denied. That would impose an undue hardship on the mother lode, given their resources and size of the organization. I think that was reasonable. Alternatives were offered. I mean, that's part of the interactive process. It's not just a one and done situation, but that requires cooperation and engagement by both sides. And it appears, based on the investigator's finding, that we have to give deference to the investigator in these situations, that it appears Ms. Mellott may have neglected to further engage in that after that final letter denying a number of her accommodation request was provided. But in any event, I similarly don't see any abuse of discretion. I know some witnesses were omitted or not interviewed, but the investigator reached out, was unable to contact them. So that was reasonable. Obviously, there's a lot that goes into these investigations, so need to give some deference and leniency to the investigators in these kinds of situations. So again, unless anyone else can convince me otherwise, I'm leaning towards overruling the objection as well. But fellow commissioners, any comment?
And perhaps just for the record, Mr. Chairman, I took into consideration as well the other two claims that were raised by the charging party as identified in the issues presented on page 4 of the case record. And again, I don't find error on the part of the investigator with regard to the claim of demoting of the charging party or denying her the freedom to choose her own working hours, and the issue with regard to retaliation because of exercising a protective activity as a disabled person. So I also took that into consideration.
Thank you, Commissioner Bartos. Commissioner Almy.
I mean, I struggled with it through 500 and some pages, 457 pages of this. And Ms. Mellott argued admirably that, there's a problem. And then the other side argued admirably that there wasn't a problem. And I mean, I was thrown back and forth between the two. But really, it comes down to, our job is to look at the investigator. Did the investigator do their job properly? And my bottom line when I come down is I'm leaning toward overruling the objection. But if somebody can convince me that there was the process was flawed, I'll certainly listen to it. But that's why I'm leaning.
Commissioner Sartain or Molina, any other thoughts?
Not me, thank you.
Would anybody care to make a motion on this case?
I'll make a motion to
go
overrule the
ahead.
objection and uphold the investigator's no reasonable cause.
Is there a second?
I'll second that.
Okay, so it's been moved and seconded that the charging party's objection to the dismissal of the complaint by the Human Rights Bureau be overruled and the dismissal affirmed. If you could please indicate your vote as I go around, beginning with Commissioner Bartos.
Commissioner Bartos, yes.
Commissioner Molina,
Yes.
Commissioner Almy,
Yes.
Commissioner Sartain.
Yes,
I will vote yes, so the motion carries unanimously. It is hereby ordered that the charging party's objection to the dismissal of the complaint is overruled and the dismissal is hereby affirmed. So with that, a written order will be prepared and mailed to the parties giving notice of our decision. And with that, I hereby conclude our consideration of the charging party's objection in the case of Mellott v. Mother Lode Theater as case number 240284.